And whatever are the hindrances or whatever are, uh, my lord, what is preventing people from going into arbitration, especially the government agencies, is taken care of. And therefore, I'm adding something.
Absolutely. And one perspective which government must also bear in mind is that if we are now today in an economy where we feel that private investment is crucial for the growth of the nation,
Government is
the
concerned.
nation, therefore, from a broader national perspective of the government, it may be the interest of one PSU to rig the arbitration. We're not saying that they do it, but I'm just telling you. But from the wider perspective of the government as a nation state, there is a vital public interest or national interest in ensuring that the process of arbitration is fair.
Absolutely,
One
absolutely.
element in that is, of course, huge public revenues are involved. If you get an award for 20,000 crores, it's part of the public revenues pay for it. Equally, government as a nation, representing the nation, has to be concerned with the fact that you must have the faith of the private sector in the arbitration process.
Who will invest?
To invest.
Yes.
And this is not just foreign investors, but domestic investors also.
Correct.
Right? So there is, in that sense, there's a governmental interest in both sides.
And public interest, that means public interest.
Governmental interest is not here only in getting favorable outcomes in the arbitration. That may be the interest of, say, ONGC, BAIL,
No, no,
particular
I understand.
contract.
No, I'm not taking it
Government's
from that.
interest is on a much broader perspective, which
I
we
have
must
not,
bear in
Lord, examined this from that myopic point of view. But I'll be very candid with your lordships, my lord, while being careful about the expressions I use. My lord, sometimes the system which we are following, that there is one arbitrator appointed by the government, PSU, or any other, my lord, a public sector body, and a private body. Sometimes, my lord, because of lack of neutrality, which includes integrity, we do not have a level playing field. I'll use my expressions, my lord, very cautiously, my lord, and I know, my lord, I'm able to convey, my lord, what I'm. Therefore, my lord, my panel, my lord, which I am improving upon, my lord, DMRC judgment is, A, they have a right to say that this is a tailor-made panel to defeat them is a valid concern. That,
Can you just say that again, Solicitor?
Lord, the panel should not only be broad-based, but these are the criteria which your lordships may consider while improving upon what DMRC has said. But I'm sorry, but I forget the first name. Therefore, I'm, for my easy reference, using it at DMRC judgment.
Say should have additional safeguards.
Yes, my lord.
Over and above volatile.
Yes,
Right?
Lord. First, the preparation of the panel must be open to all and transparent.
Just to panel preparation should be transparent, not vis-a-vis a particular case, but generally.
Generally, yes. And when I say open and transparent, I mean, I will give an example, my lord, of, say, Ministry of Urban Development and Urban Housing. They issue an advertisement that we are preparing a panel of engineers. These are the qualifying criteria. These are eligibility criteria. You must ensure that there are no vigilance angles, because engineers are always, my lord, having some vigilance angles. Sometimes you are not having any vigilance angles, just to ensure the integrity of the individual, etc., etc.
This is very important. So first was preparation of panel must be open to all and transparent. Two, I've said it two, the process. And then in two, I've said process. A, issuance of an advertisement, laying down the parameters for
anyone can apply for being included in the panel.
Issuance of an advertisement, laying down parameters, whether Roy said, laying down parameters for empanelment.
Yes, my lord. And anyone can apply who is qualified as per the panel. So that, my lord, we can decide, at least from our internal inquiries, etc., about the reputation, about the integrity issues. But this is not, my lord, very difficult to gather. So there is some, my lord, check. Otherwise, there is no check. Lord, but the expressions which are used in, my lord, in the arbitration field, I'll not use those expressions.
Again, just don't answer it immediately because you're going in a systematic way. Suppose 15 years down the line, Mr. Kaul says, well, I want to now be an arbitrator. Would you expect him to apply for empanelment? How do you deal with that issue?
That
The best will never apply for empanelment.
my lord, in international field, my lord, even eminent people, as eminent as Mr. Kaul, my lord, may send the details. I'll apply, my lord, may perhaps not be a correct word, but may send the details. Somebody else can send his details on his behalf.
Never have.
Lord, an option for invitation can also be, my lord. Lord, we are not trying to make a tailor-made panel.
See, I'll tell you, you're right. Calling for applications promotes transparency. All right. But I'll tell you a little bit of my experience because I've been now chairing the selection committees for appointing chairs of tribunals, national tribunals in India. Right, whether it's the National Green Tribunal, the Appellate Tribunal, so many of my colleagues sit on these tribunals.
Correct.
The moment we circulate an advertisement for application, best judges don't apply. They say, if I'm good enough, take me. Why should I subject to myself to more eminent professional? They'll not apply. Now, therefore, what we have, government is also, your government has found a solution to it. The government calls it a search cum selection committee. So very often when I'm right, or Secretary Consumer Affairs,
Or justice, or whichever is the
right, they normally say that, sir, we will open it out for advertisement, but it's a search cum selection committee. So they always tell us that you have the overriding power to also give us names of people who will